Hello everyone. Today we will learn some basic concepts about jurisprudence through some basic MCQs. So without wasting any time, let's start with it. The first question is, what are the four elements of state? The options are A, population, territory, sovereignty and dignity. Option B, sovereignty, government and territory and mortality. Option C, population, sovereignty and territory and equality. Or option D, population, territory, government and sovereignty. The correct answer to this question is option D. That is, the four elements of a state are population, territory, government and sovereignty. The next question is, the physical control of an object is known as what? The options are A, possessio naturals, B. Possessio civilis, C. Possessio interdicts, or D. Praetor's interdicts. The correct answer to this question is option E. That is, physical control of an object is known as possessio naturals. The next question is, who defined the administration of justice as a maintenance of right within a political community by means of physical force of the state? The options are A. Dugwit, B. Earring, C. Keaton, or D. Salmond. The correct answer to this question is option D. That means to say, Salmond defined the administration of justice as a maintenance of right within the political community by means of physical force of the state. Let's come to the next question then. Rights in re proporia means which of the following? The options are A. Right in the things of the others, B. Right in one's own things, C. Tangible right, or D. Intangible rights. The correct answer to this question is option B. That means rights in re proporia means rights in one's own thing. So, so now let's come to the next question, which is, according to the historical school, the most important source of law is which of the following? The options are A. Legislation, C. Customs, C. Judicial precedent, or D. Morality. The correct answer to this question is option B. That means to say, the customs are the most important source of law as per the historical school. The next question is, in India, which of the following cannot logically be said to be the manifestation of volcanism? The options are A. Untouchability, B. Panchayat system, C. Community labor, which is also known as Shramdan, or D. Gurukul education. The correct answer to this question is option A. That means to say, untouchability cannot be logically be said to be the manifestation of volcanism, as it discriminates people on the basis of their skin, and it violates the basic principle of equality before law that is embedded in Article 14 of the Constitution. So, let's now come to the next question, which is, in pure theory of law, the legal norm derives its validity from which of the following? The options are A. Sovereign, B. Higher legal norm, C. Higher moral norm, or D. Higher social norm. The correct answer to this question is option B. That means to say, in pure theory of law, the legal norm derives its validity from the higher legal norm. This pure theory was given by Kelsen. according to whom every law gets its validity from a higher legal norm, and at the end, every legal norm gets its validity from the grand norm. He gave the principle in a periodic form, in a form of period, periodic thing, in which the grand norm gives the validity to every other legal norm which is inferior to it. The next, coming to the next question, one of the important aspects of the sociological school is to study which of the following. The options are A. Effect of law on morality. B. The effect of law on religion. C. The effect of law on society. Or D. The effect of law on the international order. The correct answer to this question is option C. That is to say, the effect of law on society is an important aspect of the sociological school. The next question is, right to one's reputation is what type of right? The options are A. Right in rem, B. Right in personam, C. An easement right, or D. A property right. The correct answer to this question is option A. That means to say, the right to one's reputation is a form of right in rem. Let's now discuss the various rights, that is, right in rem and right in personam. Right in rem means that it is a right that is available against the world at large. It is a right to be left alone. This type of right protects people from the interference of other person into their property and ownership. These types of rights are also known as real rights or the legal rights, because this right affects on the world as well as on the person. On the other hand, other type of right is right in personam. This means that this right is available only against a specific person. It corresponds to a duty imposed on to a determinate individual. This right include only specific parties, and the outsiders are not concerned with these rights. In this, the right of a person applies or plays a part against a specific person or a group of person only, and not at a world at large. So now let's go to the next question. Salvini, Salmon and Dicey were the main supporters of which theory of personality? The options are A. Fiction theory, B. Bracket theory, C. Organic theory, or D. Concession theory. The correct answer to this question is option A. That is, Savini, Salmon and Dicey were the main supporters of fiction theory of personality. So now let's see what is actually fiction theory and what does this theory state or explains. Now let's talk about the fiction theory. What is fiction theory? This theory states that the entity of a corporation as a legal person is merely fictitious in nature and only exists with the intendment of the law. This means that any corporation, either sole or aggregate, has a fictitious personality. This personality is necessary to form an individual corporation, existing by their own and even sustaining for its members. Basically, this theory gives an artificial existence or recognition to any corporation as a legal person, so that any legal thing can be brought against that corporation at the time of conflict, and justice could prevail in that given situation or in a given issue that would rise in the future. This theory gives a basic difference between judicial and natural person. As per this theory, a natural person are those who exist for judicial purposes are judicial person, but the person who are born with its own personality are natural person. But judicial or the artificial person are created by law and does not have any natural existence. It is given the recognition as a person by the law to simplify the matter and come to a conclusion so that justice could prevail in the society. The next question: which of the following is correct according to the Kelsen? The options are A. Law is normative science. Option B. Law is a command of sovereign. Option C. Law is a means, not an end. Or option D. Law is to serve social purpose. The correct answer to this question is, according to Kelsen, law is a normative science. Coming to the next question. The next question states that who said that the task of law is social engineering? The options are A. Elric, B. Durkheim, C. Henry Maine, or D. Roscoe Pound. The correct answer to this question is option D. That is, Roscoe Pound was the one who said that the task of law was social engineering. Now let's discuss about social engineering. What is social engineering? It is based on the theory that laws are created to shape the society and regulate the people's behavior. It is basically an attempt to control the human conduct through the help of laws. Social engineering means that there should be a balance between the competing interests in a society in which the applied science are used for resolving individual and social problems. The basic aim of this theory that was propounded by Pound was that the social engineering is necessary to build a structure of a society as possible which requires the fulfillment of the satisfaction of the maximum wants with the minimum usage of resources. It involves the balancing of competing interests between an individual and the government. The next question is, what is a correlative of immunity according to Hoffeld? The options are A. Duty, B. Power, C. Liability, or D. Disability. The correct answer to this question is option D. That is, according to Hoffeld, the correlative of immunity is disability. Coming to the next question now. The next question states that jurisprudence, then, in the present hypothesis, is a lawyer's extraversion. This theory was observed by which of the following jurists? The options are A. John Locke, B. Kelsen, C. Julius Stone, or D. Earring. The correct answer to this question is option C. That is, Julius Stone stated that in the present hypothesis, jurisprudence is a lawyer's extraversion. Now, coming to the last question of this slide, which says that who said that state is absolute and is an end in itself? The options are A. Austin, B. Hobbes, C. Machiavelli, or D. Bodin. The correct answer to this question is option D. That is, Bodin was the one who stated that state is absolute and is an end in itself. So this is all for today. Thank you for hearing the session and the presentation with such a concentration and I hope that you learned something from this presentation. Thank you.